Is the Constitution of India federal? According to the traditional classification followed by the political scientists, constitutions are either unitary or federal. In a unitary constitution, the powers of the government are centralized in one government, that is the central government. The provinces are subordinate to the center. In a federal constitution, on the other hand, there is a division of powers between the federal and the state governments, and both are independent in their own spheres. There is a difference of opinion amongst the constitutional jurists about the nature of the Indian Constitution. One view is that it is a quasi-federal constitution and contains more unitary features than federal. The other view is that it is a federal constitution with a novel feature adapting itself to national emergencies. The view of the framers of the constitution is that the Indian Constitution is a federal constitution. Dr. Ambedkar, the chairman of the drafting committee, observed thus, "I think it is agreed that our constitution, notwithstanding the many provisions which are contained in it whereby the centre has been given powers to override the provinces, states, nonetheless, is a federal constitution." But some constitutional jurists hesitate to characterize the Indian Constitution as federal. It is, therefore, necessary to ascertain firstly, what federal constitution is and what are its essential characteristics, and secondly, to examine whether our constitution possesses those characteristics. Federal principle, the American Constitution, is universally regarded as an example of federal constitution. It establishes dual polity or dual form of government, that is the federal and the state governments. The powers of both the central and the state governments are divided and both are independent in their own spheres. The existence of coordinate authorities independent of each other is the gist of the federal principle. Essential characteristics of a federal constitution. A federal constitution has the following essential characteristics. 1. Distribution of powers. The distribution of powers is an essential feature of federalism. Federalism means the distribution of the powers of the state among a number of coordinate bodies, each originating in and controlled by the Constitution. The basis of such distribution of powers is that in matters of national importance, in which a uniform policy is desirable in the interest of the units, authority is entrusted to the Union, and matters of local concern remain with the states. 2. Supremacy of Constitution. A federal state derives its experience from the Constitution, just as a corporation derives its experience from the grant by which it is created. Hence, every power, executive, legislative or judicial, whether it belongs to the nation or to the individual state, is subordinate to and controlled by the Constitution. The Constitution in a federal state constitutes the supreme law of the land. 3. A written constitution. A federal constitution must almost necessarily be a written constitution. The foundations of a federal state are complicated contracts. It will be practically impossible to maintain the supremacy of the Constitution unless the terms of the Constitution have been reduced into writing. To base an arrangement of this kind upon understandings or conventions would be certain to generate misunderstandings and disagreements. 4. Rigidity. A natural corollary of a written constitution is its rigidity. A constitution which is the supreme law of the land must also be rigid. In a rigid constitution, the procedure of amendment is very complicated and difficult. This does not mean that the constitution should be legally unalterable. It simply means that the power of amending the constitution should not remain exclusively with either the central or state governments. A constitution of a country is considered to be a permanent document. It is the supreme law of the land. This supremacy of the Constitution can only be maintained if the method of amendment is rigid. 5. Authority of courts. In a federal state, the legal supremacy of the Constitution is essential for the existence of the federal system. The very nature of a federal state involves a division of powers between the central and state governments under the framework of the Constitution. It is, therefore, essential to maintain this division of powers between the two levels of governments. This must be done by some independent and impartial authority above and beyond the ordinary bodies, whether federal or state legislatures existing under the Constitution. The judiciary has, in a federal polity, the final power to interpret the Constitution and guard the entrenched provisions of the Constitution. The Indian Constitution possesses all the essential characteristics of a federal constitution mentioned above. The Constitution establishes a dual polity, a system of double government with the central government at one level and the state government at the other. There is a division of powers between the central and the state governments. Each level of government is supreme in its own sphere. The Constitution of India is written and is supreme. The provisions of the Constitution which are concerned with federal principles cannot be altered without the consent of the majority of the states. The Constitution establishes a Supreme Court to decide disputes between the Union and the states or the states. But as said earlier, some scholars hesitate to characterize the Indian Constitution as truly federal because according to them in certain circumstances the Constitution empowers the centre to interfere in the state matters and thus places the states in a subordinate position which violates the federal principle. They, therefore, use such expressions for it as quasi-federal, unitary with federal features or federal with unitary features. It may be that we deviated in respect of certain matters from the strict federalism as operating in the USA or Switzerland, but the reasons are obvious. The Indian Constitution makers defined the Indian federal structure not with an eye on theoretical but on practical considerations in designing federalism. Under the impact of world wars, international crisis, scientific and technological progress and developments and the emergence of the ideal of social welfare state, the whole concept of federalism had been undergoing a change for some time throughout the world. There are centralizing tendencies in evidence in every federation, and whether it is in USA or in Australia, strong and powerful national governments have emerged in every federation. The framers of the Indian Constitution took note of these tendencies and kept in view the practical needs of the country designed on federal structure not on the footing that it should conform to some theoretical, definite or standard pattern, but on basis that it should be able to subserve the need of the vast and diverse country like India. The Indian Constitution, therefore, constitutes a new bold experiment in the area of federalism. In short, it may be concluded that the Constitution of India is neither purely federal nor purely unitary but is a combination of both. It is a union of composite state of a novel type. It enshrines the principle that in spite of federalism, the national interest ought to be paramount. Thus, the Indian Constitution is mainly federal with unique safeguards for enforcing national unity and growth.